What's up, everybody? Welcome back into an episode of The Lawyer You Know. And today we are jumping back into Karen Reed's civil case as there are more potential filings, I guess we'll call it. They do it a little bit different in Massachusetts. We'll talk about that. We're going to read through the filing from the quote unquote House defendants, as they're known at this point. Then we are going to watch the civil hearing, the status hearing that had a bunch of lawyers on it, which I thought was very interesting to listen to after reading the House defendants' response to Karen Reed's team potentially consolidating all of these lawsuits together in the state court. You guys have a lot of questions, and I know that because I've gotten a ton of them over social media over the weekend. We are going to answer as many of those questions as we possibly can today while we look at these documents and watch this hearing together. Let's get to it. So we usually post our podcasts on Monday, and I feel like we haven't done a Monday live in a really long time. So I'm excited to be here. This is a live. Most of you that are just here on Mondays are more used to a premiere where we're premiering the podcast early in the morning. But today, because it's Thanksgiving week, things are a little bit different. And over the holidays, when Christmas comes up, there's going to be more of a little bit of a different schedule. So just make sure you are subscribed. Make sure you've hit that reminder bell so you get all the notifications. Make sure you like this video, tell your friends to subscribe, to come to our channel, to talk about all these cases, because 2026 feels like it's going to be a year for new, fresh cases that we haven't covered as much of before. 2025 feels like there was a resolution of a lot of cases. Koberger, Diddy, Karen Reed, Maya even is maybe picking up again with this appeal. And I saw this comment said there's a motion for rehearing on the Maya appeal. Could you go over the answer brief, explain what it means to get en banc? Love from Germany. Yeah, that's a whole other video. And if you guys are interested on it, then let me know. Let me know in the comments and on social media. But 2026 feels like it's going to be a fresh start because 2025 was an ending to so many cases we have followed for so many years. And one of the new yet old cases that still is in our lives is Karen Reed. Now we have the civil case. A lot of people had questions about like the lawyer fund in a civil case versus a criminal case. You guys can let me know what you think and what questions you have, and we can break it down. When we get to the hearing, we will talk about how Alan Jackson probably and some of the other attorneys are already, well, specifically Alan Jackson, is noticing a difference when you practice criminal law than when you practice civil law. It's very different throughout the entire litigation process, and I think he realized that in this civil hearing. Not that he didn't know, but it's going to become apparent in some of these civil hearings and some of these things that happened in the civil court. Sam said, has anyone heard about Alessia and Yannetti's YouTube channel lately? So Yannetti reached out not too long ago asking if they could like pick my brain or whatever about it. And I said, absolutely, whatever you guys need, whenever you need it. So I don't think it's dead. I don't think it's a lost cause. I think it's absolutely happening. So everybody keep an eye out for it. I'm sure it's going to be amazing with those two guys. They are amazing guys, interesting guys as well. So these are the House defendants. And the way I guess from what I hear in Massachusetts is that you don't actually file certain things. You serve it to the other side. They serve a response, then you serve them together. And then the judge has both documents when the judge wants to make a decision. So when Karen Reed's team made mention in court about consolidating all of these cases together, I guess they put the third-party defendants on notice. And this was the response the third-party defendants had. Now, we talked about the potential defamation case going forward against Karen Reed and Aidan Carney, how that might be coming from these House defendants. Well, this is where that came from, I believe, is the document we are going to read together, which is basically their response, their defense, their argument as to why these cases all should not be consolidated together, why that is such a bad idea and creates so many problems. So we're going to read through this, and then we are going to listen to the hearing, which to me was very interesting after reading this. I actually listened to the hearing before I read this. So, okay, defendant Reed's proposed cross-claim and related factual allegations against the McCabe's, the Alberts, the Higgins are a vile work of fiction lacking any basis in fact, evidence, or law. Indeed, these outlandish allegations are part of the defendant Reed's scheme to defame and wrongly malign the Commonwealth witnesses to evade responsibility of her actions the morning of January 29th, 22 for causing the death of Officer John O'Keefe. So this lawyer is planning on jumping right in the deep end, using the verbiage, terms, and language that we have seen and become accustomed to in the Karen Reed case. Her lawyers like to do it. This lawyer seemingly is going to like to do it. So that is how this is going to be. And this is obviously also responding to a document that we haven't seen, which was the defense writing some kind of motion, trying to bring in those third-party defendants and consolidate all this. Now, we know they filed a separate action in a separate jurisdiction. So you can do that, and that can be it. And now they can go in the separate jurisdiction. Or later, you can file a motion to try and consolidate all these. But that's a more difficult path than what it seemed like they were going to do. So when I was reading the complaint with John, it was, my guess that they had decided to go a different route, but we hadn't seen anything officially saying they weren't going to do what they originally said in the first ever civil hearing. So all of this stuff is going on in the background. All we really know is what has been filed, which is two separate actions. The wrongful death complaint filed by the O'Keefes that Karen Reed is the defendant and will defend with C.F. McCarthy's et al., and then the complaint filed by Karen Reed against Proctor, Tully, Higgins, Albert McCabe, Buchanan, et cetera, et cetera. So those are two separate actions, not consolidated together. And we'll talk about the issues that are going to pop up because of that, which is what Karen Reed brought up in the first motion. But everybody was fighting Karen Reed on that, saying that's not the right thing to do. That's not a good idea. Yes, this is an actual live, grass folk, an actual live. We're all here together. We're doing it live. The Commonwealth witnesses vigorously dispute the defendant Reed's allegations and will defend against these false claims. The Commonwealth's witnesses' defense will include motions to dismiss, potential removal of these claims to federal court, as well as counterclaims against defendant Reed and third-party Aiden Carney, aka Turtle Boy, for defamation and other torts that they have committed individually and in concert. So this is kind of what the other video we talked about. This is kind of where it came from. But this is the more interesting sentence to me, or part of the sentence to me. Might not get the headlines, but the fact that there are going to be a bunch of defense motions, including motions to dismiss, that's a big one, potential removal to federal court, and counterclaims, this is what creates some of the difficulty of consolidating all of these cases together. Because if the O'Keefes deserve civil justice, then to have that justice delayed because of all these motions to dismiss and removal of these claims to federal court and all these counterclaims, then it makes sense. You can't delay one case if you have another case that you're arguing has no legal relevance to the case at hand. If that's what everybody wants to say, fine. I think that's a reasonable argument. So these motions that are very proper motions that happen in almost every civil case, if they're saying these are coming, then I can understand the argument against consolidating all these together. The Commonwealth witnesses, however, should not be forced to litigate these false allegations. First off, if you think they're false allegations that you shouldn't have to be forced to litigate, I get it. But whatever venue that happens in, you're still going to be forced to litigate it. And their own defamation claims in this pending lawsuit brought by the family of Officer O'Keefe against the defendant Reed and two other defendants for their role in causing the death of John O'Keefe. Bringing defendant Reed's proposed cross-claim into this action, along with the Commonwealth witnesses' defamation and other tort claims, is procedurally improper at this stage and will substantially increase the claims parties' factual disputes and legal questions in this case without any evident economies of scale. So I don't disagree with that. I said this from the jump. There's so much going on. There's so many different claims and cross-claims and counterclaims that it would be pretty laborious to put all of these together. So why would they want this case removed to federal court, Debbie asked. Because they may deal with some 1983 actions, and when you're dealing with potentially law enforcement defendants, sometimes federal court is more proper, number one. Number two, federal court is usually better for a defendant. You don't have as much control in the jury selection process. There's not as much of an open discovery in federal court as there is in state court. Usually those cases move more quickly in federal court. I think generally they may favor the defendant, but it really depends on the case. So we'll see, because they say we might want to remove it to federal court. They're not saying they're going to remove it to federal court. Daybreak, finally caught alive. I've been wanting to ask you if you are thinking about covering Antonio Brown. The answer to that is yes. Yes, I am thinking about covering Antonio Brown. And yes, I've already talked to Mark Eiglarsh about it, who is representing Antonio Brown, if you remember him from the resource officer trial in the Parkland shooter case. Really, really great Florida attorney on it. So I know he's going to be doing good things, and we already have our eye on it. We'll see if anything pops. And if you guys have questions, of course, about Antonio Brown, that's really how I pick the cases we cover, right? You know this. Okay. Moreover, plaintiff's wrongful death action is currently past the motion to dismiss phase, with discovery having commenced. If the defendant Reed is permitted to file these claims relating to her criminal prosecution in this case, the motion practice on her pleadings will likely take months. Then, if defendant Reed's proposed cross-claim survives dismissal, the Commonwealth witnesses will file their own counterclaims against defendant Reed and Mr. Carney in this action. Those counterclaims could again trigger months of motion practice. As such, the current discovery schedule could almost be over before the pleadings are closed on the defendant's Reed proposed expansion of the case. I don't disagree. Delay, delay, delay. Therefore, we have to keep these cases separate. And it only makes sense, right? We have to keep these cases separate so that we don't delay the O'Keefe case, right? That seems to be the main and number one argument of this document. Remember that when we're listening to the civil hearing, that the main argument in this document is we can't consolidate all these cases because it would delay the O'Keefe's case, and that is wrong, and we can't delay the O'Keefe discovery. Accordingly, defendant Reed's motion should be denied, and she should be directed to file her proposed pleading, if at all, in a separate action, which she ended up doing. In that separate action, depending on what claims survive dismissal, it may be appropriate for the parties to consolidate cases pursuant to Rule 42 of the Massachusetts Rules of Criminal Procedure. Haha. The other thing I mentioned, maybe we consolidate later, it's possible. At this time, however, it is too early to determine whether judicial economy and efficiency could be served by consolidation in the future. So it's too early to determine if we need to consolidate for judicial economy. Nevertheless, it is evident that there's no basis to warrant joinder at this time, and the present motion should be denied. Now, you also have to think, if Karen Reed's team and this team were exchanging these documents, maybe Reed's team read it and was like, not a bad idea. Let's try doing this, and then we consolidate them together. Factual and procedural background. As set forth in plaintiff's complaint, on the evening of January 28th, defendant consumed 9 alcoholic drinks during an appropriate 3-hour period, different restaurants, getting behind the wheel, hitting her boyfriend. At that time, Reed was clearly intoxicated, unable to safely drive. Nevertheless, Reed drove to O'Keefe to the Alberts house. After O'Keefe got out, Reed hit him with her car rather than stop. After seriously injuring him, she left. I'm just kind of summarizing the way they're throwing the facts out there. By the way, these facts are not really as important to this motion as you might think, but of course, they want to add them in there because they like to give this factual basis. After hitting him, she goes home. Approximately 4:30, she frantically calls people. She shows up back at 34 Fairview at 6 a.m. looking for the body. According to testimony at trial, Reed spoke to the police, told the police she did not see O'Keefe enter the house. Similarly, to defendant Reed, the police questioned each of the Commonwealth witnesses. Each told them O'Keefe never entered the house. A few days later, Reed was arrested for causing the death of O'Keefe. In the spring of 23, while awaiting trial, individually and in conjunction with Aidan Carney, she embarked on a strategy to defame the McCabe's, the Alberts, the Higgins by falsely accusing them of killing and covering up John O'Keefe. Reed did so to evade responsibility for causing the death of O'Keefe by diverting attention from herself. As outlined in the police affidavit, Reed started to coordinate with Mr. Carney in April of 23, initially using an intermediary to coordinate Mr. Carney's public communications. Defendant Reed and Carney also relied on the messaging app Signal to communicate and coordinate strategy. Reed and Carney's unlawful campaign to defame the Commonwealth witnesses has caused them substantial injury. So this sounds like a complaint, potentially. The factual background of a complaint. So what would make it federal? It could be a federal question, diversity of citizenship, the amount in controversy over a certain amount of money. There's a lot of reasons that it could get to federal court. It could just be that it's a federal question based on 1983 action. We'll see. The plaintiff's federal court in criminal cases and civil is very different. Federal civil is a jurisdiction that only certain cases are properly filed there. And if they are, then that's where they should go. It doesn't mean it's worse or you're definitely going to lose like it feels like in criminal court. August of 24, plaintiffs filed the present wrongful death action. That's the O'Keefe's against defendant Reed. The court stayed this wrongful death case pending defendant's retrial. Sorry, I missed the spring of 24. Defendant Reed stood trial, hung jury. And then 25, retried. She didn't take the stand in her defense, which they mention every time, which I think is interesting. The jury found the government failed. I love this too. The jury found the government failed to meet its burden of proof on all accounts, except the charge of operating a vehicle under the influence. So as opposed to saying she's not guilty or exonerated, they say the government failed to meet its burden of proof. And this is just an example of lawyers being lawyers. Lawyers can turn anything into a win. Lawyers can twist anything into sounding good for them. So just, it's just an example of that. Myself included, right? I'm not saying I'm not one to read something to where it sounds better in my version of events during an argument in a case, right? That's what we do. We formulate arguments based on the facts. We make the facts fit the law and make that argument to a jury. And it just depends on if the jury agrees or disagrees. After the verdict, this wrongful death action was resumed. In August of 25, defendant Reed moved to dismiss the complaint. In October of 25, the court denied her motion to dismiss except one count. On October 20th of 25, defendant Reed answered the complaint. So, that's like just now. We just got past the answer, but it was filed in August of 24. So there was, of course, this little thing called a retrial in the middle. But let's say August 25th is when it resumed. So the quote unquote motions to dismiss and the initial motion practice done by the defense took about 2 months, from August 25 to October 25. That time period is important because we're trying to avoid that delay happening again for the discovery to start. And what they're arguing is, you see, this took 2 months, Judge. If we now allow this consolidation, we're going to file motions to dismiss against all the claims against us. That's 2 more months. Then when we file our counterclaims, Reed is going to file motions to dismiss. That's going to take another 2 months. So now you're delaying the O'Keefe discovery 6 months from August of 25, the 2 months for their case, the 2 months for Reed's case, and the 2 months for the House defendant's case. Now you're delaying discovery 6 months. That's not right. You shouldn't do that. And we need to get it together and appropriately have this discovery take place. Somebody said voice sync out, or is it just me? So let me know. I can try to refresh. If you guys refresh, that might help. But yeah, let me know and I'll try to check it. Kelsey usually will let me know if there's an issue with the audio. Can you claim factual background visibly intoxicated when you testified the exact opposite? Under oath, she looked fine, sober. So if you have a reason to believe and a good faith basis for it, maybe they can say something they saw on the video said that she was visibly intoxicated. There are ways that you can say it, even if an individual did not say that, or one individual witness. Civil cases can go on forever though, right? Yeah, they go on forever. And keep that in mind. These civil cases can drag and drag and drag for a million different reasons. Okay, most people are saying it's fine with them. Okay, so on October 28th, defendant Reed served this motion. So served is different than filed. Served it on these House defendants is how I'm reading this. Served this motion pursuant to Rule 21 governing misjoinder of parties, and asked this court to allow her to file 9-count proposed cross-claim with a mix of state and federal causes of action against 10 new parties, including the Commonwealth witnesses. So we have 2 McCabe's, 2 Alberts, Higgins, Tully, Proctor, Buchanan. That's 8. So this says 10. So I don't know if this sounds like it might be similar, might be different from the complaint that we read in a different jurisdiction. So, maybe Karen Reed is still holding back some that she was planning on filing here. We'll see. Okay. Rule 21 is not the proper vehicle for the defendant Reed to join the Commonwealth witnesses and assert proposed cross-claims. As an initial matter, the present motion is procedurally deficient as defendant Reed mistakenly brings her motion under Rule 21 of the Massachusetts Rule of Civil Procedure, which is not relevant to her proposal to add new cross-claim defendants and counterclaims related to her criminal prosecution to this wrongful death action. Rule 21 governs misjoinder of parties and states misjoinder of parties is not a ground for dismissing an action. On motion or on its own, the court may at any time or just terms add or drop a party. The court may also sever any claim against a party. Under this rule, the court has discretion to overcome a technical problem of misjoinder by adding the correct party or severing claims against a party. So this is basically like a mistake was made or something we know we need to do, and the judge can do it under this rule, and they're arguing not appropriate for what Karen Reed's trying to use it for. Rule 21 is inapplicable here. And this may be the reason Karen Reed's team was like, okay, they're probably legally right. Let's just serve the complaint somewhere else. Or they have a different way that they think is better to try and join these claims later. Could be either one. Defendant Reed does not seek to cure a deficiency in the current pleadings. Instead, she seeks to add entirely new parties and subject them to entirely new claims surrounding not the circumstances of Officer O'Keefe's death, but rather her own criminal investigation and prosecution. The complaint seems to say otherwise, that it does have to do with John O'Keefe's death, that they in fact caused the death, which would be a defense in the O'Keefe civil claim. So I don't know what this document says they're responding to. So indeed, defendant Reed's citation to these cases in her motion highlights her misuse of Rule 21. In this case, the court held the regional subsidiaries of the Kaiser Foundation Health Plan could be added as plaintiffs pursuant to Rule 21 to the lawsuit after trial to avoid a standing challenge on damages. The court found that there was no prejudice to the defendant Pfizer by Rule 21 joinder because Pfizer had the opportunity to fully litigate the damages associated with the subsidiaries throughout discovery and at trial. In other words, this case concerned a technical correction of the parties, not claims, in a case which the parties had effectively litigated as if the new parties were always part of the lawsuit. This is not so here. Reed's proposed new pleading brings in new parties and new claims that are not part of the pending wrongful death action. Without reading the document, I tend to think they probably have a good argument here. While the wrongful death action and defendant Reed's new pleadings are broadly related to the tragic death of O'Keefe, the wrongful death action directly addressed what happened to Officer O'Keefe the evening of January 29th, while defendant Reed's proposed claims and allegations relate to the events that occurred after the death during her multi-year prosecution. Instead, defendant Reed should have sought to amend her answer under Rule 15 and sought to join new parties, including the Commonwealth witnesses, under Mass Rule 20, which governs permissive joinder. Defendant failed to do so, and that alone warrants denial of this motion. Ashley said, can we get an update from Bettero soon on the podcast? Yes, we will get Bettero back on soon. Next week's podcast, I've already got the guests lined up, and I'm incredibly excited. It's the Monday after Thanksgiving, so make sure you're subscribed to the podcast because it's going to be good. It's going to be really fun. I can't wait. Even if this court were to treat the defendant Reed's motion as being made under Rule 20, the motion should still be denied. Under Rule 20, this court has the discretion to allow joinder of parties and counterclaims, but should only do so where it would promote trial convenience and not where it would result in prejudice, expense, or delay. Here, the court should decline to exercise such discretion. Defendant Reed's proposal to join the Commonwealth witnesses and other third parties to this wrongful death action would not advance, here we go, to join these together would not advance judicial economy at this stage. You'll notice that all of these Reed defendants and the O'Keefes seem to be, pretty hand in hand. Their lawyers seem to be talking. They seem to be working together. They seem to have, a common enemy makes you my friend, right? It really seems like that. So that's why to read this, and then when we hear the civil hearing, something's not jiving. Something's not jiving. It seems like you're arguing out of both sides of your mouth. No, the podcast guest for Monday has nothing to do with Karen Reed. It has to do with a completely different trial. Can't wait to pick his brain, talk to him, have you guys kind of meet him and get to know him in a way that I don't think has happened yet publicly after a lot of people watched him in trial. Okay. Rather would substantially increase the complexity of the pretrial proceedings and result in delay and prejudice to the Commonwealth witnesses and the plaintiffs. There are several reasons for this court to not exercise its discretion, but they're kind of admitting it's just up to the judicial discretion to join the Commonwealth witnesses to the existing wrongful death action. Defendant Reed's proposed course of action will prejudice the Commonwealth witnesses' discovery and jurisdictional rights and will substantially complicate and delay the pending wrongful death action with new parties, claims, factual disputes, and legal issues without any genuine judicial efficiency gains. Without any judicial efficiency gains. I'm highlighting these for a reason, okay? Now, it could create some jurisdictional issues if they want to remove it to federal court, if these were all allowed to be joined together, but we'll wait. Okay. The Commonwealth witnesses will have substantial motions to dismiss if defendant Reed is allowed to file her proposed cross claims in this action. If defendant Reed is permitted to file the proposed cross claims against the Commonwealth witnesses in this wrongful death action, or if she files it in a separate action, those pleadings will be subject to substantial motion practice. Anticipated motions to dismiss include requests for dismissal based on the Massachusetts Strategic Litigation Against Public Participation Act, the anti-SLAPP statute, as well as on the statute of limitations grounds. Such motions are likely to be successful, or at the very least, substantially narrow the scope of defendant Reed's proposed claims. So they're like, we think we're going to win some of these motions to dismiss, basically, is what they're saying there. Yes, everybody please hit that like button. For everybody asking if it's Alan Jackson, no, it is not Alan Jackson. I did see he was on Brother Counsel. I haven't had a chance to go watch that yet. That's awesome. I've talked to Alan Jackson a bunch, told him, hey, it'd be cool if we come on, if you come on and talk about the civil litigation or civil lawsuit. I'm glad he went on Brother Counsel and talked about that. There's nothing really more to say at this point, I think. So we'll see if something comes up and something's interesting and something's fun and is cool for a cool conversation. We will always do it. We will always give the people what they want. But this one is something you guys asked for a couple weeks ago. I've been working on setting it up, and probably one of the people I've liked watching in trial the most. Probably one of the lawyers I have singularly enjoyed watching in trial the most out of every lawyer that we have watched together. Okay. Moreover, under the anti-SLAPP statute, all discovery in this proceeding would be automatically stayed once the Commonwealth witnesses file that special motion to dismiss. While the court could resume discovery for some existing claims in the wrongful death action, there is a serious risk of multi-tiered discovery if defendant Reed's proposed cross-claims are brought into this case at this time. These timing issues are compounded because the Commonwealth witnesses would have the right to an immediate appeal if the anti-SLAPP motion were denied. Given these significant legal deficiencies in Reed's proposed cross-claims, this motion practice could take the party several months, if not longer, to brief and for the court to resolve these motion issues. So to argue, again, that this is just going to be too complicated, there's going to be too many delays, there's no judicial economy there, right? That's something we have to wait for. That's something we have to wait for and see. That's what they're arguing here. Lally would be amazing. I would love to have Adam Lally on. Absolutely love to have Adam Lally. The invitation is open, my friend. You reach out to me, shoot me an email, laurayounknow@gmail.com, and we'll make it happen. Adam Lally. That would be awesome. That would be hilarious. Further, if some of the defendant Reed's proposed cross-claims were to survive dismissal, the Commonwealth witnesses could be compelled to file their defamation action as counterclaims against defendant Reed and Mr. Carney in the present action. That could result in further motion practice. In the meantime, discovery in the present wrongful death action could be substantially complete. Indeed, the current discovery schedule ends in August of 26, which may leave only a few months of discovery on defendant Reed's cross-claims and the Commonwealth witnesses' defamation counterclaims. That truncated discovery would needlessly and substantially prejudice the Commonwealth witnesses, which alone also warrants a denial of the motion and directed that defendant Reed pursue a separate action. Alternatively, discovery in the wrongful death action may be stayed pending these motions, which would needlessly delay adjudication of this lawsuit. So basically, again, they're arguing that if you allow this to be combined, then you could delay that lawsuit. So if you don't allow these cases to be combined, you won't delay discovery in the lawsuit. That's what this sounds like, right? That's what this sounds like. Is it true? Is it not? I don't know. Let's see what they're going to argue later. Defendant Reed's joinder strategy will prejudice the Commonwealth witnesses by likely foreclosing their right to remove the litigation to federal court. Next, the defendant Reed's proposed cross-claim includes several counts arising out of federal law, including count 4. Conspiracy to deprive Ms. Reed of her Fourth Amendment rights against McCabe, Alberts, and Higgins. Absurd as it is on the merits, if the defendant Reed files this pleading in a separate action, the defendants would have the statutory right to remove defendant Reed's complaint to federal court. So this is because it is a federal question, right? It is something that is better handled by federal court, basically, is where this would be. And that's why you have the option potentially to move it to federal court. Doesn't mean automatic. However, by adding these claims as proposed cross-claims in the plaintiff's wrongful death action against the proposed counterclaim defendant, defendant Reed will likely foreclose Commonwealth witnesses' right to seek the removal to federal court. In particular, the Supreme Court has held that removal under 28 U.S.C. 1441A is not permitted for counterclaim defendants. And they cite these cases. Given defendants Reed's tenuous basis to seek leave to join claims relating to her criminal prosecution to this wrongful death action, the court should avoid inflicting undue and unfair prejudice upon the proposed new cross-claim defendants. By denying the motion and forcing defendant Reed to file this pleading as a new action, the court will ensure that the proposed counterclaim defendants' jurisdictional rights are not inappropriately foreclosed. If this motion is allowed, the Commonwealth witnesses will have to file defamation and other related counterclaims against the defendant Reed and third-party Carney in this wrongful death action. So basically this section, they're saying, you think this is big and complicated now, Judge? Just wait till we file our claims and our complaints. It's just going to get bigger and more complicated. Finally, defendant Reed's motion would not only expand the present wrongful death action with her proposed cross claims and the additional parties related to her criminal prosecution, but the Commonwealth witnesses would also be forced to file counterclaims against defendant Reed for defamation and other torts in this action. The Commonwealth witnesses also would have to join third party Mr. Kearney to this action to assert similar counterclaims for defamation and related torts. As explained above, defendant Reed and Mr. Carney, both in concert and separately, have defamed and substantially injured the Commonwealth witnesses through a myriad of false statements about them for which the Commonwealth witnesses have planned to seek justice in a separate action. While the Commonwealth witnesses contend their defamation claims and other torts against the defendant should proceed in a separate lawsuit, if Reed is permitted to bring her proposed claims in this action, Commonwealth witnesses may be compelled similarly to bring their defamation claim as well. The additional claims and parties related to the unlawful conduct by defendant Reed and Carney after the death of O'Keefe would further complicate this action by increasing the number of parties, claims, disputes, and legal questions. As a result, defendant Reed's motion would not create any judicial efficiencies at this stage by having these disputed claims based on different facts and time periods against different parties in a single lawsuit. That's an important sentence. Okay. So you're starting to understand how complicated this is, right? Everybody's starting to understand, right? And we're getting through it. Here the definition of inextricably intertwined is something we need to talk about here, and something that's very important in civil law. Inextricably intertwined. That means if you cannot litigate one case without bringing all the crap from another case in, they should be consolidated. And yes, that's a legal term to say all the crap in another case. So that's basically what Karen Reed's team said in the hearing, and probably what their document says. This crap is too inextricably intertwined, Judge. We've got to bring it all together. And the O'Keefes and the House defendants say things like, no way, Judge, not inextricably intertwined, totally different, totally separate. This line right here, based on different facts and time periods against different parties in a single lawsuit. So what they're saying is the O'Keefe lawsuit against Reed and McCarthy's et al. Is pre and death of John O'Keefe. These other cases are post-death of John O'Keefe. Number one, let's answer those two questions. Let's first start on, is the O'Keefe lawsuit really just pre-death and the death of John O'Keefe? The answer is very clearly no. Why is it no? Because they brought in claims of intentional infliction of emotional distress and negligent infliction of emotional distress based on actions of Karen Reed after John O'Keefe's death. And they also mention Aidan Carney in their papers. So that time period is off. It is not just pre up to the death of John O'Keefe. So question number one is no. Now question number two, is the Reed v. House defendants et al. And House defendants v. Reed only a time period post John O'Keefe's death? The answer also is a very clear no, at least not according to the factual allegations in Karen Reed's complaint. They include the night of, before, and during the death of John O'Keefe. And after, of course. So those timelines and those time periods and those factual allegations start to overlap and potentially get inextricably intertwined. They may be proving me wrong. Like I was thinking, yeah, these should probably be separate. But as I read this document and as I listen to this hearing that we're going to listen to together, if I was the judge, I might be thinking, oh, as miserable and annoying as it might be to join all this together, is that what we have to do for judicial economy? And there's going to be certain things that are unfair about joining all of this together, but does it make more sense than it does less sense? And you're starting to see kind of the balancing act a judge has to do. Michelle said, I'm lost about the talking out of both sides of their mouth. Can you explain that part? That's referring to Diller, yes, but they agreed though. I don't know what you mean they agreed though, but here's the point of this filing is these are completely separate. We have to separate all this in order for the O'Keefe case to be okay. If we don't separate this, it's going to delay discovery and make discovery more difficult for the O'Keefes. And if we do keep it separate, that's going to simplify it for the O'Keefes. That's going to allow the O'Keefe case to not have delay in discovery. That's going to allow the O'Keefe case to go forward separate from this separate action. That's what I believe this document to be saying. Now, when we get to the hearing, you'll hear the argument from the other side coming from the O'Keefes, who are in lockstep with the House defendants. Kat, hey, P and HMO, LOL. What happens if all suits get combined, then down the road, the O'Keefes drop their suit? Does it make a mess for the intertwined suits, or is it not a big deal, procedurally speaking? The lawsuits that are still open would continue. The lawsuits that are still open would continue. Now, it might be easier if it's a separate lawsuit and you settle one and you still have a separate lawsuit, but we have done it before where we have lots of parties, some of them settle, and you continue going forward against the ones that did not settle. It's not that uncommon. Georgia Kaplan, no. So usually for prosecutors and judges, I would say the only way I would ever have them on is if I was friends with them beforehand. Most of them probably wouldn't want to come on, and I don't want to get like a judge in trouble or a prosecutor in trouble if I don't know them well enough. I'd have to talk to them a bunch before I had them on. So this is a private attorney. Okay, last page here, and then we'll get to the civil hearing. Consolidation may be appropriate between the separate lawsuits at a later time. So this is good too. Defendant Reed provides no genuine justification for adding proposed cross-claims and the 10 new cross-claim defendants to the pending wrongful death action. As stated earlier, Reed's proposal will substantially expand the scope of the pending lawsuit, including dramatically increasing the number of claims, parties, issues of factual dispute, and legal questions for resolution. It also risks unduly prejudicing the Commonwealth witnesses by truncating discovery on their claims and artificially foreclosing jurisdictional issues. However, it is possible that if defendant Reed pursues her proposed cross-claims in a separate action, as she should be required to, the parties in the court may determine after motion practice is complete that there may be some efficiencies from consolidating, I think they mean for consolidating discovery or the claims for trial under Rule 42. So they agree that in the future, that could change. That could change. Which is kind of what I said from the jump. Start them separate, maybe consolidate them later, right? That's what I've said. But already at this very early hearing, you'll see why maybe that's not the best thing. At that time, the parties in the court will be able to assess the remaining claims and parties, including the defamation claims against the Reed defendant and Mr. Carney, and be better situated to determine whether consolidation is warranted. And potentially, if some of these do settle, right? If some of these do settle, then maybe that makes it easier. For the foregoing reasons, the Commonwealth witnesses respectfully request the court deny Reed's motion pursuant to Rule 21 to file a proposed cross-claim in the pending wrongful death lawsuit. Okay? So that's all from the document. And now we will get to the hearing. This is the Young Jerks stream. So thanks to Young Jerks for grabbing the stream, putting it out here. Nice, clean version of it. All right. Here we go.
Start taking depositions in the county action. I don't want to be prejudiced when we start taking depositions in this case, not knowing what information that they have already assembled when it's time for us to be able to inquire.
Okay, so unfortunately, I looked at a couple different versions of this and I didn't catch anything before this. I wish I could have. I didn't get anything they were arguing about before this. But if I'm going to take some context clues, he is arguing that he wants to make sure he gets all the discovery that they're getting in these other cases. And this is the lawyer for the O'Keefe family, Diller, I think his name is. So right off the bat, he's arguing, hey, I need all the discovery they're doing in that case. And I don't want them to have discovery I don't have. Do you know what that sounds like? It sounds like the exact opposite argument we just read from the House defendants. He's saying, I need that discovery. I can't do my job without that discovery. And if I were him, I'd be careful about making this argument. Ashley said the court wasn't letting people join the stream on time. Okay, so just nobody was able to get before this. That's fine. That's fine. We can still understand. We can still understand. So from my perspective, if you're going to argue you need all the discovery from that other case before you can take your depositions, aren't you saying they're inextricably intertwined? Aren't you saying that all of the arguments about delaying justice and delaying discovery are going to happen whether or not we consolidate these cases? Isn't that exactly the opposite of what you just said before? So which is it? Do you want to keep these cases separate, but then get all the discovery from that other case? Because, by the way, you're not just automatically entitled to discovery in other cases. You have to prove that it is applicable and relevant or potentially relevant to your case. So are you saying all the discovery in the other case is relevant to your case now? Because that to me would act like these cases need to be joined. If I were him and I did not want these cases to be consolidated, what I would say is, Judge, we're ready to go. We will ask the right discovery questions in interrogatories, requests for production. Interrogatories are written questions that they give us written answers. Requests for production are, please give me these documents, and they give us these documents, and then take depositions. I know it's relevant to my case. I'm ready to go. I will ask all the appropriate questions. If they don't turn something over, I will file motions to compel. I will prepare my depositions. I will talk to the witnesses I think are relevant. If I think the House defendants are relevant, I'll get discovery and deposition testimony from them. If I think Buchanan and Proctor and Tully are relevant, I will get depositions of them and requests for productions, non-party subpoenas. I will do that work that we do in every single case. This other case, if you're really saying different time period, and not applicable to my case and not inextricably intertwined, then just do your work on your case and consider them third parties. Consider them non-parties. Consider them witnesses. That's how you would do it if you really think all of this is separate. But the way he's arguing right off the bat to me makes it seem like everybody tends to agree here that the House defendant's case and the O'Keefe's case completely overlap. And we're going to cause delays in each other's cases. We're going to have to share information in each other's cases. From my perspective, that's what it feels like. That's what it feels like.
Your Honor, let me just quickly respond to that. First of all, I'm a little
Now this is Karen Reed's civil attorneys.
concerned by listening to my brother counsel read from what looks like a scripted message that doesn't seem to deal
It's like a minor shot that he's reading from a scripted message.
with any issues because there's been no motion to compel that's been served on us relating to those answers. There's been nothing filed with the court. Instead, my brother counsel is reading from a script for what I'm guessing is some other purpose. And what we'd like to do is we'd like to just...
Attorney Waters.
Okay, and then the judge is going to pop on. But what this defense lawyer is arguing is he's acting like we're not giving him something, like we're not turning over something. Yet the proper way you do this is you serve a discovery request. We have a certain amount of days to respond. If we don't respond, you send a 10-day letter, a good faith letter saying, hey, can you give us this? You meet and confer. Potentially, they're going to talk about a meet and confer in a second. And if we still don't give it to you, or if we object and you disagree with our objection, then you file a motion to compel and you argue, we can respond, and we have a hearing in which we argue in front of you, judge, and you make a call. Now, by the way, if that explanation made you go, oh, all that for a discovery answer or for a document, yeah, that's why this stuff takes forever. And in civil cases, I can't tell you how many times I ask for something, they say no, they either don't answer it, so I have to wait for the entire time period to go by, or they object with a boilerplate stupid objection, and I've got to send a 10-day good faith letter, I've got to meet and confer, all while we know they're not going to give us these documents. Then I have to set a hearing, then I have to file a motion to compel, then I have to set a hearing, which could take months, which is so annoying. It's so incredibly annoying how delayed all of this is, but technically, as common defense lawyers are, which Karen Reed's lawyers are doing here, they're like, well, judge, they didn't handle this appropriately. So we should still have all these other delays until they file a motion to compel. But technically, they're right. Technically, they're right. They didn't file a motion to compel. He should not be making this argument here that we haven't turned over discovery if they haven't given us all the proper legal opportunity to respond.
Excuse me for interrupting, but maybe we'll take this as a 9C conference. You heard what he's looking for.
So a 9C conference is basically a conferral, right? A good faith conferral with the other side. And you have to reach out. You got to say, hey, are you going to give us these documents? Well, maybe if you just give us pages 1 through 5 instead of 1 through 7, will that suffice? No, I need all 7. Okay, well, we're not going to give you all 7. Okay, if you're not going to, we got to let the judge decide. That's kind of the meet and confer, right? And states are putting more and more of this in. I know Florida is. I know when we just did the rules, we're putting more and more of this in, which to me, I didn't love. The judges love it. And the judges that are on the Civil Rules Committee are like, we have to do this. We have to do this because too many lawyers are doing things without talking to each other. And I'm like, we're trying to talk to them, but they don't pick up the phone. But so we all talk through, and they're doing a lot more of this, right? They're doing a lot more of, you have to meet and confer with the other side. You've got to discuss what your differences are, see if you can work it out so that I know when you show up to court that you've tried and you still can't work this out. So the judge is like, hey, let's short circuit this a little bit. Why don't you guys have your meet and confer right now so that if we can't get an agreement, they can just file their motion to compel later? Because a lot of times you cannot file certain motions without meeting and conferring, without certain timelines passing by to give each side the appropriate time and opportunity to respond and cure any problem.
What do you say to it?
Your Honor, actually, I don't know what he's talking about. For what I'm guessing is some other purpose. And what we'd like to do is we'd like to just...
Attorney Waters, excuse me for interrupting, but maybe we'll take this as a 9C conference. You heard what he's looking for. What do you say to it?
Your Honor, actually, I don't know what he's talking about, to be candid. I think that Karen's statements have been consistent, and they're certainly consistent with the lawsuit that's been filed in Bristol County. So my brother counsel is going to have to be more specific about what he thinks is inconsistent. I don't think it is at all. And that's usually why motion practice is a good idea.
A lot of shots taken early on. That's usually why motion practice is a good idea. Meaning, if we just say like, they didn't give us what we asked for, Judge, it's like, well, what do you mean? Be more specific. What did you ask for? How much of it? And if you make it in writing and you ask for something with specificity, that's why lawyers love specificity. We like to know what we're up against. It's not trial by ambush. We like to know, and we like to go and do our research, right? Lawyers don't know everything off the top of their head. People want them to. People only think lawyers are smart if they can answer every question under the sun. That's not how good lawyers work. We go back, we research, we put together an argument, we look at the facts, we do some research on the cases, and we argue our position by morphing all that together. And so we have to know what we're working with, what we're dealing with. And in order to know that, we have to know what you're arguing, what you're asking for. So if you don't put it in writing and send it to us, sometimes it can get confusing and we're not sure what we need to respond to. And that makes the judge's job harder. So nobody likes that.
Attorney Diller, I guess we'll consider the 9C conference conducted and file whatever motion you want to file.
Thank you, Your Honor.
And that's mostly how these meet and confers go. The judge is like, well, I guess that's your meet and confer. I guess you're not going to agree. So why don't you file your motion to compel? And the defense is like, yes, please file your motion to compel. Let us know what you're trying to compel from us. What discovery are you saying we didn't turn over? Because if it doesn't really exist, you're not going to be able to file a motion to compel. And if we did turn it over, that's going to be a pretty easy response. We turned it over on this date, Judge. Here's the email where we filed it or we served it on.
Anyone from, what's the status of the discovery with CNC Hospitality and GNS? Attorney Diller, did you receive responses?
I did. Well, both parties had reached out to us over the history of this case. We may have propounded that discovery even before, well, they reached out to us over the history of this case. We may have propounded that discovery even before, while the criminal matter was going on, maybe around the time of the stay. But they then reached out to us at separate occasions and were very upfront about the fact that they're compiling discovery and needed more time. We allowed that additional time. Yesterday, we received some discovery, which I think I indicated to you I have not reviewed yet, but we have received discovery from both bars. One bar, and forgive me for not recognizing which one is which, one bar may have sent me some preliminary discovery a couple weeks ago and then supplemented it yesterday. The other bar sent me a batch of discovery yesterday, none of which have I had an opportunity at this stage to review.
Okay. Anyone else want to offer anything on behalf of any of the parties?
Yeah.
Attorney Hassett on here for Waterfall?
Yes, Your Honor. Attorney Hassett for Waterfall.
Afternoon. Do you want to offer anything?
Your Honor, I would just say that with respect to the discovery, we have in fact responded to the plaintiff's discovery after an extension was granted. We did the interrogatory answers. Those have been complete. The document responses were, as Attorney Diller indicated, in two.
So you notice he said the interrogatories are complete, which are written questions like, how many people did you have working that day? Who was the bartender that night? Whatever. And they write in the answers. They don't write them. They type in the answers and then they file them. Then he said the document production. That's what they're talking about, requests for production, right? And you have to actually produce documents, meaning like, what insurance did you have at the time? Give me the insurance policy. Did you have any training procedures or manuals? Give me those training procedures or manuals, whatever it may be. Do you have a clock in, clock out sheet? Go ahead, give us that. So that's what he's talking about, so that we know what is an interrogatory, what is a request for production, what's the difference, what's the difference between an interrogatory and an interrogation or a deposition, right? One is written questions and answers. The other one is in person under oath. You can also impeach somebody with their interrogatory questions. They have to swear them under oath, just so you know. So if they ask Karen Reed something and she types in the answer as an interrogatory, then swears under oath, it's not like, oh, no, that wasn't me, that was my lawyers. No, that's your statement and you can be impeached with that as well.
Stages, we completed that as well. We have yet to propound discovery ourselves at this point. Obviously,
propounding discovery ourselves mean they haven't asked their questions yet. So when you propound discovery, you're asking interrogatory questions, you're requesting documents, right? When you receive discovery, somebody else is asking you the questions and you're answering them. So all of the defendants are going to get discovery from the plaintiffs, but then they're also going to respond and give them their own discovery. So the O'Keeffes have asked discovery questions and documents of Karen Reed and of both the bars. But both the bars and Karen Reed get to also ask the O'Keeffes questions and for documents. And then, of course, that's what we say. When lawyers think about expanding this case, 10 more defendants, and then maybe another one if you had Turtle Boy on and the counterclaims of those 10 defendants. Now you have 10 more sets of discovery times 2 more defendants. So 20 sets. But then those 2 defendants get to propound 10 sets of discovery. So 40 sets of discovery is what we're adding. And every single one of those, you can have 20 questions, 30 questions. And you can object to some of those questions. You cannot answer some of those questions. So it's literally hundreds, if not thousands of opportunities for hearings and delays. But just because that is a fact doesn't mean you can't consolidate them. Because if that's going to be a fact, whether or not you consolidate the cases, then you should consolidate them for the other reasons that it makes it more economical. So that's the question. If we separate, is it really going to make things go faster and avoid delay? Or is the delay going to happen either way? And it actually makes sense to combine these cases.
there's a history in this case that occurred on through 2 criminal trials. It was our approach to see what documents were produced from the various keeper depositions and the other document requests among the parties. And then from there, after looking through the documents, make a decision as to what more pointed interrogatory answers we would propound. And as was indicated earlier, we've got a fairly lengthy discovery on a average tracking order, which permits discovery through next August. So in terms of our own discovery and our plan on propounding it, we were hopeful that we'd be able to wade through some of the voluminous documents first.
And the way you decide what you're going to ask in discovery, in this case, you've got to read through 2 trials worth of transcripts to see what is relevant to you and what documents you want to look at. Oof. Oof. Michelle said, which lawyers represent who? So Hassett represents one of the bars. That's who's speaking right now. Jackson, we know who he represents. Where it says Sheehan Finney, which is this one right here, that has 3 people sitting at a big conference room table. That's also Karen Reed's lawyers. Bottom left, Mark Diller represents the O'Keefes. I think that's all I know at this point, but we'll hear whoever else steps up and says who they represent. And obviously, top left is the judge. Thank you, Mama Cass, for gifting 5 Lawyer You Know memberships. That's awesome. Thank you so much.
Who's here for McCarthy's? Is it Attorney Smith?
All right, she's muted right now, but the top left, female here, top left with her hand raised, that's who represents McCarthy's, I believe.
Clerk Donovan, is Attorney Smith?
Yes, Your Honor, I asked her
Yes.
to unmute.
Yes, Your Honor.
Good afternoon.
Good afternoon, Your Honor. Attorney Tamara Smith for CF McCarthy's. Thank you for the opportunity to speak. Yes, as has been stated, we did produce several hundred pages of documents yesterday, have responded fully to the plaintiff's answers, to the plaintiff's interrogatory requests. And like counsel for Waterfall, there's, as indicated in this call today, over 1 million or about 1 million pages and documents that are forthcoming. So the thought here would be to see what is there so that there's not duplication of effort and additional requests put out that are already answered by what is already forthcoming.
Okay. Anything else from Ms. Reed's side, Mr. Waters?
Nothing from our side, Your Honor. Thank you.
Attorney Diller, anything else from the plaintiffs?
No, I think that, but I do expect that we will convene a 9C amongst all the parties after this to discuss what efforts, if any, will be made to consolidate discovery on the other pending matter. Only to.
Why would you need to consolidate discovery? That would be my question. Why do you need to consolidate discovery if it has nothing to do with your case and you don't think these cases should be consolidated? Every time, if I really wanted it, right? Karen Reed's team has got to do their work and due diligence and saying, do we really want to consolidate these? And if you do, then every single chance you get, every time Diller or anybody says these cases are the same, we need to consolidate this, it's going to delay our case and the discovery in the other case. Any chance you get to do that, you need to take it and say, Judge, seems like they're arguing we need to consolidate these. Peter, does it matter to the defamation suit that Karen has only made statements in court against the McAlberts, unlike Aiden, who has done it publicly? There are very different cases against Karen Reed and against Aiden Carney. Anybody that's on YouTube talking about it every single day versus a defendant who has mostly asserted their Fifth Amendment right outside some interviews, which were not made in court, definitely not made in court. So not all of her statements were. They would be litigated differently. Korg said, I'm taking my first law school exam final a week from Thursday. Lawyer, you know, has been a great study break. Any exam tips, Peter? Happy Turkey Day. So my number one tip for any law school taker is get to know your professor. It's kind of like get to know your judge, get to know your jury. What do they like? Because I had certain professors who wanted a shorter exam and get to the point. I knew other professors that were like, put as many things down as you can, because I issue spot and I say, okay, they gave me this definition. They said this legal word. Those are my favorite classes because I would just dump it all onto the page. I would like have all of this in my head and just dump it down all onto the page. And those are the exams that I aced, where it was like, you just say as much as you want, type, no word limit. And here are all the different definitions I memorized and ways I could put them together and ways I could explain answers and define things and whatever it may be. So figure out your professor, what they like. I don't think you can over prepare for a law school exam. I like to know as much as possible. I memorize as much as I can. I have a pretty good memory, so I can remember kind of what it looks like on a page or where it is and what's bolded. I'll make my own outlines with different colors and things and which ones go together. And if I get a question about this, what I always like to do is, if I can, it's almost like YouTube, right? If you guys ask me certain questions, I have a bank of all the things that apply to that question that I want to get out there to help explain to you guys. I did the same thing on a law school test. If I got a question about this, then I would be like, okay, these are the 4 things I think I can pop in here to help explain and get points. So that's what I tried to do, is have as much information I could ready to answer every single question, regardless of which one came up.
To ensure that we not worry about there being,
Okay, I'm going to back it up because he's talking about the discovery in both cases.
they discuss what efforts, if any, will be made to consolidate discovery on the other pending matter, only to ensure that we not worry about there being information that is discovered in the other case relevant to our case, which would prejudice us if we're not privy to.
So he's saying we're worried about information that could be discovered in the other case that would be relevant to our case. If it's relevant to your case, that would make it discoverable to your case. And I'm just thinking like a lawyer, right? If we're not going to consolidate these cases, if something is relevant to my case, I have the burden and duty as a lawyer to ask for that. And then they have the duty to turn it over to me. And if they don't, and I file a motion to compel and they don't, they can be sanctioned. There can be spoliation issues. There can be instructions given to the jury that they withheld relevant information they knew existed and was relevant because they turned it over in another case that has nothing to do with ours, if that's what I'm arguing. So from my perspective, if something's relevant to your case, whether it's a part of another case or not, you should already be asking for that. You should already be getting that. It shouldn't delay you because there's another case going on. Does that make sense to you guys? You get what you tracking with me? He's acting like the only way he can get relevant documents is to get discovery in another case. That shouldn't be the case. If it's relevant to my case, I have all the tools I need to get it within my case.
Well, it's great you're trying to agree to something, but again, I think it's difficult to have an agreement without knowing who's going to be involved in the other case, who the attorneys are. Attorney Waters, what's the status of the notice?
Hold on, before we get to Attorney Waters, it's like the judge is like, well, that's kind of hard. We don't know who the lawyers are going to be in the other case. And if these cases are not consolidated together, those lawyers don't have to give you anything, right? Like the lawyer representing Tully or Proctor or even Higgins and McCabe's and Alberts, they don't have to give you anything. It's a totally separate case. If it's all consolidated, now that's different. How we share information is different in cases like that.
The governmental entities.
Yeah, you talking about the presentment letters, Your Honor?
Yes.
I think if they weren't sent yesterday, they'll be being sent today. And we've had conversations with both counsel for those entities about having a shortened presentment period. We expect agreement on that. I got my fingers crossed, but we expect agreement on that, in which case we won't be delayed in processing whatever procedural or motions that those parties want to make in that Bristol County case.
What's the status?
It sounds like they are trying to expedite the other Karen Reed case, right? With, I don't know what we want to call them, the House defendants. The Karen Reed case with the House defendants are like, hey, can we get this moving quicker so you guys can do your motions to dismiss and you can file your counterclaims and we can file our motions to dismiss so that we can get along to potentially figuring out if it is better to consolidate these cases. And I really think this could be in response to what we read at the first half of this episode, which was those House defendants' response to Karen Reed's to Karen Reed's potential cross claim. Maybe they're like, okay, let's work together. Let's do this initial part. Let's do discovery and see if we should consolidate these. We'll see.
This on the service on the individual.
By the way, we're past an hour and we still have at least, I don't know, 10, 15 minutes left. So everybody hit that like button. We're going to go over the power hour here. We're going to go into some overtime. Hopefully that's okay with everybody. If it is, hit the like button. But let's keep riding.
Defendants in the Bristol case.
The answer is I don't know, Your Honor. I haven't received information where we've gotten good service, and if we've not gotten it, I expect to get it shortly. My colleague Aaron Rosenberg can specify to that.
Your Honor, we've got counsel for, I believe, 2 of the individual defendants in the Bristol County case. One counsel has already agreed to accept service. The other counsel suggested that he will. We're just going back and forth. So we're hopeful we'll be able to get acceptance from the majority of those defendants and only have to serve a couple. So we don't foresee any delays on that front.
And all they're talking about is perfecting service of the lawsuit, because most clocks start when service is perfected. So you tick on that clock once service is perfected. So just because you file the lawsuit, it doesn't start most clocks. You have to serve the defendant so they know that that lawsuit exists. And there are specific ways you have to serve the defendant. One of the ways is if the lawyer says, I'll accept service on their behalf, which has already happened with at least one of the defendants in that case.
Attorney Diller, you talked about consolidation. Attorney Waters said they weren't going to move it this time. You, Attorney Diller, intend on moving to consolidate this point.
He's like, wait a second, are you moving to consolidate? Because that's what it sounds like with a lot of Attorney Diller's arguments. Like, are you trying to consolidate? It's like, no, they're the ones arguing against consolidation. But Judge, I understand why you're confused.
We had discussed so the answer is yes, for purposes of discovery only.
So we want to consolidate for purposes of discovery only, which is interesting because delays in discovery is exactly one of the reasons they said we can't consolidate. That doesn't help judicial economy. There's almost no reason why we should consolidate at this point, was the argument made in the response again by the House defendants. But now he's like, we want to consolidate just for discovery. It almost seems like you're trying to pick and choose. And it's like, we can either consolidate or not. And if you think there's enough overlap and enough of the cases inextricably intertwined for discovery, sounds like we should consolidate.
Just to the extent that works itself out. There was this
into the extent that works itself out. I'm not sure what he means by that, but I think he's starting to figure out like, am I making too many arguments to consolidate?
Discussion during that entire motion practice that took place over the last 2 months. The counsel for these other parties had all reached out. So we have spoken with all of the counsel who were involved in the Bristol case because they were apparently going to be brought into this case. So
he has been in discussion with all of the House defendants counsel, which we know that's one person. And then I guess I don't know if Tully, Proctor, and Buchanan have lawyers yet, but they've been in communication since the last hearing with those House defendants. The same House defendants that wrote that motion. That seems to be saying exactly the opposite of what Diller is saying here. Sounds like they're trying to have it both ways.
there was that discussion with them. So I do know who that counsel is. I have the briefing from those counsel. There was discussion within some of the briefing that it should be consolidated for purposes of discovery purposes.
We just read that. Doesn't sound like that's what they were saying. It doesn't sound like that's what they were saying.
I don't know where things stand because it's now outside in the Bristol case, but I do expect that there's awareness of who all the lawyers are, and we could potentially discuss options. Obviously we had wanted this to all resolve itself months ago. And unfortunately, it wasn't until Monday night that the defendants withdrew their motion and started on a different track.
So it wasn't until Monday that the defendants, meaning Karen Reed, withdrew her motion to consolidate all these together and went now separately. It's like, but it sounds like that's what they were asking for, the House defendants, in their response. Is it not? Why is this so hard? You argued so hard for them to go separate track, and now you're like, well, that separate track creates issues for us, Judge.
The different mindset, but we will happily be proactive in trying to get that moving in the best direction for our case in the wrongful death case.
How much time do you think?
So B asked, why did she withdraw? She just withdrew her motion to consolidate them at this point and decided to start down a different track. They can try to consolidate them later, but she didn't withdraw the case, just the route they were going to go to try and make these affirmative claims, like they said. Is it Sarah Boone, LMAO? So close, so close.
Would take.
Well, what I don't know, Your Honor, is whether some of the parties are going to move to dismiss in the Bristol case and whether that will hold up the discovery there. That's the big unknown. So I wish I had that crystal ball, and I don't today, but I anticipate that there are some overlapping parties that may stay in the Bristol case, to which we'll need discovery there, and that discovery will overlap. I want to be clear that we're agreeing for discovery purposes to avoid prejudice. We are tabling whether or not these matters need to be tried together.
I mean, they're tabling it now. Did it not seem like they were an absolute hard no at the hearing? Now they're tabling it, but they do agree to consolidate for discovery purposes only. He's like, I want to be clear. I'm not agreeing to consolidate all this together. But oh, how far have they come from the hearing we all had together? Now, Karen Reed's team kind of sprung it on them, so they weren't very prepared for that. And they just automatically, sometimes lawyers are like, wait, you want X, I want Y. You want red, I want blue. It's like they can't even think about, well, actually, is red better for me? Maybe I want red too. And they went back and they thought about it. And then maybe they were like, okay, maybe this isn't so bad for us. So I think all of this is still up in the air. But they're admitting they want consolidation for discovery. To me, it's like, then just do it all together. I don't get it. I don't get why you're acting like this.
Will only be known once we have full understanding of what comes out in discovery.
Okay. Well, let's pick a date in December so we can find out where the Bristol action is at and find out what other discovery issues remain so we can try and sort through those.
It's like everything they do, it sounds like, is going to have to say, well, we need to see what's going on with the Bristol case. We need to see what's going on with the Bristol case first. We can't do this without figuring out where the Bristol case is at. We don't want to affect the Bristol case. As a lawyer in my ear, that sounds like they need to be together.
Do you anticipate filing a motion to compel, Attorney Diller?
Yeah, the interrogatory answer, yes.
Okay, so let's pick a date for that. The date in December. When can you have the motion served?
We can start working on that right away. Within probably the Tuesday after Thanksgiving is what I believe we could shoot for.
Okay, that's December 2nd. Gives the defendant till December 12th. Let's pick a date the next week. We'll have a hearing on the motion to compel and a further status hearing. About December 18th? An issue for anyone?
Your Honor, it is for me. I have a pre-existing hearing scheduled that day, but the 16th and the 17th, I'm open.
All right, how
If
about
I
the
could,
16th or the 17th?
if I could have just a moment, Your Honor, to confer with my client. The 16th and 17th don't work for Ms. Reed. Either the 18th, I know that that's bad for Mr. Waters, the 19th would work.
Okay. So the first time Alan Jackson pipes in, he says, I need to confer with my client. So we all know whose ear Karen Reed has, or vice versa. And Alan Jackson's like, I'm speaking to Karen Reed right now. Let's see what she has. And he says, okay, these days don't work for her. How does the 19th work? And you would think that seems very reasonable for a lawyer to want his client to be involved and want his client to be able to be there, right? That's how it is. And if anybody says anything else, you pound the table and you say, but the Constitution, you're trying to throw her in prison for the rest of her life. She has a constitutionally protected right to be present at every important phase of her case.
19th works. for
Attorney
me.
Jackson? Attorney Jackson, I can understand Ms. Reed wants to be there at every matter, but I don't necessarily think there are constitutional issues relative to the civil case.
I agree.
And just like he got from Canoni, he's like, well, this is how we do it in Massachusetts. The court's like, well, in civil matters, Mr. Jackson, if we tried to figure out a hearing date for every McCabe, Albert, Higgins, Carney, Tully, Proctor, Buchanan, C.F. McCarthy's representative, O'Keefe representative, Waterfall representative, you can understand the judge is like, that would be physically impossible. It's hard enough to get all you lawyers who are paid or it's their job for you to be here. It's hard enough to find a hearing date. Hard enough to find a hearing date with all of you that if I also had to do this for each one of your clients or representatives, that'd be impossible. Now, you might say that's unfair. I would agree with you. I wish the client could be at every single one, but it is virtually impossible in civil cases. So he's not being a jerk. He's not being rude. He's not being mean to Alan Jackson, but this is a difference in the criminal case versus the civil case. I talk about it all the time when my dad does certain things in civil cases. I'm like, Dad, relax. It's a civil case, not a criminal case. Certain rights are different. He knows, but he's like, you have a lot more leeway and a lot more power because of the Constitution in criminal cases than you do in civil cases. And that's just a difference, and you got to deal with it. And you also got to be like, okay, Karen, this is when it is. So if you can make it happen. And also, if it's by Zoom, it's a lot easier. Even if she's on vacation or whatever, pop your phone out and you can be on Zoom and you can sit there and listen. Or you can watch a recording of it afterwards. Alan Jackson didn't even say a word in this hearing. It's not like Karen Reed was going to make an argument in this hearing. But I completely understand him doing that and wanting to do that. And if Karen Reed wants to be there as her lawyer, he should try to do it. I would do the same thing. I have had clients who want to be at everything. And guess what? I ask the judge and I push for it. And when there's only one client and one defendant, and the defendant is an insurance company or a corporation, judges usually don't care. And they'll just allow it to happen. They'll just be like, sure, yeah, if your client wants to be there, no problem. So for the most part, judges will allow it. But when it gets into incredibly complex, like I have another case where there's 43 plaintiffs and 2 defendants. They're not going to let us say our client needs to be at every single one. They're just not going to. And I understand that. And if my client really wanted to, I would try to push for it. I would get as many dates as they're available, and I would present them with those options, but I would make them understand through discussion that it's not always going to be that way. And I'm sure Karen Reed understands that. I'm sure Alan Jackson has explained that. But I just thought that was very interesting because that is a big difference between civil and criminal cases. And a lot of people were screaming at this judge for saying that to Alan Jackson.
Constitution be there at every matter, but I don't necessarily think there are constitutional issues relative to the civil case.
I agree. I'm not suggesting that she has a constitutional right to be there, but I know that she wishes to participate in her own defense, and she would like to be there if we can accommodate her schedule.
And that's the perfect answer. If we can accommodate, we want to make it happen. That's it.
Right, but if the court starts having to accommodate every party's schedule, it would grind the courts to a halt.
I understand. I get that. There's only one defendant though. So for what that's
Well,
worth.
there are other defendants in this
And there's definitely more than one defendant. There's 3 defendants in this case and multiple plaintiffs as well.
case.
Your Honor, for what it's worth, I can also do December 19th.
Will it be remote, Your Honor, by Zoom? I have things that week, but if it's going to be remote by Zoom, then I can try to, I can definitely be available and then not worry about moving things around on the week of the 15th.
What do we have that day? 19th. Hang on 1 second. I have to have the clerk check something. No, I'm checking the schedule here, Clerk Donovan.
Schedule there, okay.
Afternoon's wide open.
Thank you.
That works.
December 19th, we'll schedule it virtually for now.
Thank you.
That works, Your Honor. Thank you.
Thank you, Your Honor. I appreciate it.
And see, by asking nicely, you catch more flies with honey than you do with vinegar. They accommodate, they get it set for 12/19. I think that's pretty much it. I'll just make sure.
Okay?
Okay, so just for the record, this matter is continued to December 19th, 2025 at this point in time. Thank you all.
All right. So maybe not a ton happened, but it was a pretty interesting hearing. And I think there's going to be a lot of fireworks in a lot of these early hearings, especially when we get like motions to compel. They're not turning over stuff. I'm interested to hear how much they talk about that Bristol case every time they have a hearing for this case, because every time they mention it, I'm going to have a little note in my head saying, it's another argument for consolidation. That's another argument for consolidation. Can consolidation be for discovery only, or is it all or nothing? I mean, if they agree that they're going to consolidate discovery, then fine. But if I am Karen Reed's defense team in this case, and I wanted to consolidate the cases, and they said, no, I'm going to say, Judge, they're going to make my life harder by making me do discovery consolidated, but not the other stuff consolidated. Why can't we just consolidate the whole case? I thought the reason was because it was too hard for the O'Keefes. And now they're the ones forcing this consolidation. That doesn't make sense to me. That doesn't make sense to me. So we'll see how it goes. I appreciate you guys joining me. I know it was a little bit of a longer one. Hopefully you hit that like button. If not, hit it now and subscribe to our page. We'll be back. I'm planning on doing shows Monday, Tuesday, Wednesday this week, and maybe something will drop this weekend. We'll see. But I know with Thanksgiving coming up, we all have a lot to be thankful for. I appreciate you guys so much. I'm really thankful that you come and hang out and ask your questions and get in the chat and make this so much more interesting for all of us here. And we learn so much together. And we're coming up on another year of learning so much about the justice system, so much about each other, so much about how things should work in the world. So I appreciate you guys so much. But that's all we got for this one. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.